So welcome everyone. We'll get started in just a second. Just to say, there are a few chairs up in the front and some in the middle. Please come and take a seat if you can. At some point, if we reach capacity, we're going to have people standing out in the halls. So if you are able to move in and fill in and take seats, that will make sure that we have more room. So if anybody wants to come, there's two seats in this section here.
There.
Okay.
Good evening, and thank you all for coming. I'm Trisanya Crawford. I'm one of the board members for Building Bridges for the Greater Good. I'm going to share a little bit about Building Bridges. All volunteer community and active, founded by Mr. Ofi Kyer in 2012. And in the wake of the murder of African-American teenager Trayvon Martin, who was fatally shot while walking home by a neighbor who thought he looked suspicious. Building Bridges' vision, is a community of equality, unity, and love where everyone can thrive.
Thanks, Trisanya. And my name is Catherine Barnes. I'm also a board member. And I think as Trisanya explained, we've always had a really core interest in justice issues and in creating the criminal legal system form of justice, as well as justice in other forms writ large. So we were so pleased to be able to host a forum tonight and to have both Mr. Joe Perry and Mr. John Baber agree to come. And I believe this is the only forum that you have thus far? Or maybe there'll be some more?
I think there's one more that they invited us to, the Democratic Committee and the LGBTQ community.
Great,
are hosting one
fantastic.
in October.
Wonderful, so we'll be sure to make sure people know about that one as well. But this will be, I think, the first time you'll have had a chance to address the community. And so the format for this evening is that we're going to begin with offering them both about 3 minutes each for opening remarks. Then we have a number of questions that we enlisted some of the topics and issues from the community, and then the board crafted some questions. We're sorry we're not able to get to all the topics, but we hope we'll get a good range of them. And I must say, you'll note when we're doing them that we're not trying to inform our candidates of the issues. We are trying to make the way we ask the questions a way of raising awareness of the issues in our community about what we think of as some pretty key justice issues. So hence, hopefully the questions themselves will be a little bit educational, but we'll be very interested in your responses to them. Then we will open up to questions from the public. Depending on how many questions there are, we will have about 1 minute each of response. If there's not many questions, we'll probably give you a bit more time. We would like to finish up by 7:30 this evening. Trisanya, you're going to announce how we're going to do this in terms of seeking to be fair.
Sure. So each candidate will get a maximum of 3 minutes to answer the question once the question is read to you. So right now we would like to invite each of you to share your opening remarks.
Actually, first we'll do a coin toss.
Right. I got you. We would like to invite each of you to share your opening remarks about why you are running for office of the Commonwealth Attorney and your priorities and approach if elected. So I'll let you guys battle that out for heads or tails. Who wants heads? Who wants tails?
Tails?
That's 4. Make sure this is on. Can everybody hear me? Thank you all for being here. A lot of you I've met, a lot of you I've gotten to know over the last 7.5 years. I've been here in Staunton working in the Commonwealth Attorney's office. A lot of familiar faces in the crowd, and I appreciate everybody being here, everybody taking interest in this debate, in this forum, to meet the candidates, to hear about our background, to hear about why we're running for this job. and what we intend to do if we are elected. My name is Joe Perry. I've been with the Commonwealth Attorney's Office for the last 7.5 years. Is that good? Yeah. I came here in March of 2018. Mr. Gaines, Jeff Gaines, our elected Commonwealth Attorney, hired me to join his office as an assistant prosecutor. A few years after that, in 2020, he promoted me to Chief Deputy Commonwealth Attorney. I had a long background prior to that in the practice of law. I've been a prosecutor altogether for 15 years. For about 5 years, I did private work and some defense work, court-appointed defense work, and DSS work. But I wanted to return to prosecution. That was really the job that I went to law school for. It had always been my passion. And Jeff gave me that opportunity back in March of 2018 to join his office. And I have worked every day for the last 7.5 years for this city. I was given the opportunity in 2020 to become his chief deputy, and I took that job with a great sense of responsibility because it is a difficult job with a lot of responsibility, and I have worked so hard for this city since I've been here, and the reason I'm running for this job, the reason I'm running for the elected Commonwealth Attorney is because I am committed to this city. I'm committed to keeping the city safe. I'm committed to working with all the different agencies, the police department, probation offices, nonprofits, all the different groups that we work with. It really is a collaborative job. And I've built those relationships over the last 7.5 years. In the last 5 years as chief deputy, not only have I supervised all the other attorneys in the office, not Mr. Gaines, but the other attorneys in the office, I have been focused on prosecuting child abuse cases. And those are the hardest cases that we see. Unfortunately, we have like any jurisdiction, we have our share of those cases, really more than our share. And I've worked very, very hard, diligently over the last 5 years to prosecute those cases, to protect the innocent in our community. And the reason I'm running is to keep doing that. I believe it is the duty of the Commonwealth Attorney to keep the city safe. I've taken that commitment very seriously, and I want to keep doing that work for the people of Staunton. Thank you.
All right, my turn. Hi everyone, my name is John Baber. I'm running for Commonwealth Attorney. And the reason I'm running is because I care deeply about public service, about the community, and about justice. Justice done the right way. Now what does that mean? That's just a tagline. What does it mean? It kind of boiled down. The elevator pitch is that violent people have to go to jail for the most part. However, there are lots of sick and suffering people that need help in this community. And if they get that help, they'll be able to break the cycle. We'll be able to improve public safety. So it's twofold. And I'd like to tell you how those philosophies can coexist. So to start, I agree with Mr. Perry. People that hurt children, victims of violent crime, those are terrible things. And violent people need to be held accountable, tried in court, sent to jail, protect the community. That's why we went to law school. That's why we became prosecutors. That's the job. That's a good lawyer that does that. I'm a good lawyer. But there's a second component, which is helping the sick and suffering, drug addicts, mental illness, poverty, a lot of issues that permeate society, clog the system. And there's where my experience really comes in. So if we can address those issues, drug treatment right when arrest happens, mental health treatment, job placement, pretrial diversion, community mediation, restorative justice, again, like a bunch of buzzwords, but plans in order to get people on their feet, stop kicking the can, and get people a little bit of help that gets them out of the cycle and can solve a lot of the public safety issue, along with alleviate court dockets, decrowd jails, make the citizens and business owners more comfortable. So how did I come to that philosophy? Why am I unique to be able to do this job? Well, first, I have a vision for the office. It's one of leadership. The Commonwealth Attorney is an elected leader who's supposed to connect with the people. I've knocked on 4,000 doors in this community, not to get elected, but to ask the people what they want, to see what their cares and concerns are, and that's how I'll run the office. How I run for office is how I'll run the office. I was a public defender in Baltimore City. I trained police in a police academy to do their job, all the legal aspects. I've been a prosecutor here in Staunton and Waynesboro, and before that I was a high school teacher. I know people, and this is a people job. Additionally, I live in town with my wife and my uncontrollable toddler. And I care deeply, I'm vested in this community and want to see that its social fabric and its community stays as great as it is while upholding the Constitution and doing a good job every day fairly and impartially. Thank you.
Thank you all both.
Thank you all both so very much for your opening remarks. And now we'll have a number of questions that will hopefully help to dive deeper. And I think what we're going to do is after that initial coin toss, we're going to just start a pattern of alternating throughout the rest of the evening. So even though it's a spiel to continue, we'll start with Mr. Weber and then we'll switch to we'll kind of alternate it back and forth. So first, a couple of questions. That to see your thoughts on some of the overall patterns of incarceration in Staunton, including some disparities that seem to exist within our system. So as people may know, Staunton actually has a comparatively high incarceration rate. Well, this data is a few years old now. It's our incarceration rate, which is the share of the population that is jailed, is in the highest 25th percent of cities and counties in Virginia, even though our actual crime rate is not in that top 25%. How do you explain this comparatively high rate? And if you were elected, how might you respond to it? And so please, Mr. Baker, we'll begin with you, and then we'll switch to Mr. Perry.
How long do we have? 3 minutes?
Oh, apologies. 2 minutes. Now we're going to tighten up.
That's a bit more than a 2-minute answer. However, briefly, I think that suggests a philosophy in this community that I don't know that the community agrees with. Again, about their polling the community. Now, I can't speak to specifics, but what I'll tell you is that jail's not the answer for most things. It's an answer to protect the public from people. However, it doesn't fix much. Jail's easy. Fixing the problem through using services, taking a chance, working again and again on people is hard. And I'm here to do the hard job. Now, some people have to go to jail, and jail's a good timeout, and it's a good box to put someone in when they can't be trusted to keep communities safe. However, I'd say, why is it that way? I can't give you a real study, but I can tell you, because nobody's come along like me and suggested this. And why not? Because this is the first time in a generation that we've had a contested election. It's not next person for the job, it's best person for the job. And I'm here with my experience in people, and I say, I want to try a different way, bringing service providers together, having an interdisciplinary roundtable, figuring out how to synergize. I know that's a business word, but figure out how to get the treatment and resources we have here streamlined and implemented to do a better job for the people that are most vulnerable. Thank you. Oh, just 30 seconds? I got more to say. So, again, I think it's easy to send people to jail because you don't have to explain to anyone why you're hard on crime. But when you use something that you're vested in as a prosecutor called prosecutorial discretion, and you take a chance on a human being, you have to look everyone in the community in the eye, tell them why you did it, and say, here's why, here's the process, we're all going to trust. And you have to set up the right process to do that. Thank you.
Thank you. I think, like John, I can't speak to the specific statistical breakdown of what that looks like. What I can say is I've been in the office for 7.5 years. I've worked with a group of prosecutors in that office who are committed to the city. They work very, very hard. And the people that we are incarcerating are people that have hurt people, that have committed violent acts, or that have repeatedly violated probation, that have been given chances and have not followed the rules. In my job, I've prosecuted people who hurt kids. That has been my main focus, prosecuting child abuse cases. Those are very difficult cases. And those people, as John said, deserve incarceration. We're not trying to put people in jail or prison because they have an addiction. We're not trying to put people in jail or prison because they have mental health issues. We have in Staunton recovery court, we have therapeutic docket. We go out of our way to try to help people, to try to give people services. I do a lot of work in juvenile court, and the whole thrust of juvenile court is to keep kids out of the system, to get kids help so that they're not being incarcerated. I've worked in that court for, again, the entire time I've been here, 7.5 years, so I can speak with authority on that we do everything we can to get kids out of the criminal justice system so that when they're adults, we don't see them again. But we have in St. Augusta, Waynesboro has really been, in a lot of ways, on the cutting edge of criminal justice. We have, again, recovery court, therapeutic docket. We've had alternative sentencing programs for a very long time. And we all endeavor, everybody in the system endeavors to try to help people, to try to get people help for addiction or mental health issues. But the people that need to be incarcerated, we are endeavoring to make sure that they are held accountable for their crime.
The next question will start with you, Mr. Beard. The local criminal legal system displays racial disparity. Black citizens make up less than 7% of the population at the catchment areas, but over 24% of those held in Middle River Regional Jail. Why do you think this racial disparity exists, and what steps, if any, would you take to reduce it?
Well, first of all, I agree with that statistic, and I think it does reflect to some degree systemic racism that is, producing that kind of disparity. That being said, with every single case that comes before our office, for every prosecutor in our office, we look at it individually. What is the best outcome in this particular case for this particular individual? We work with the different agencies. We talk with not just the police officers involved, but probation officers, court services officers, whoever it might be. It's really a collaborative job. You cannot do this job by yourself. And trying to get the best result in every single case. So there may be systemic factors that have led to that kind of disparity. And I think that in every particular case, you as a prosecutor should look at what is the best outcome for the community. And in some cases, it may be looking at mitigating factors for that particular defendant. In other cases, looking at the victim side of things may be more important. But you're looking at it case by case. How do we get the best result for in this particular case for the community? I don't believe the job of the prosecutor is to fix society. I don't think we can do that. I think that is too tall of an order for a position whose job is to enforce the law. We don't make the law. We don't make policy in this office. We prosecute cases. We should use our discretion and our judgment in every single case that comes before us to try to do the right thing. And I believe, and I've said this before, and this is what I tell people when I'm out campaigning, judgment is critical to this job. Judgment in every case, decisions you make day in, day out for the best interest of the community. And judgment only comes from experience. And I'm the candidate that has 15 years of experience as a prosecutor, 7.5 years of dedicated commitment to this city.
Same question. It's a tall order there to explain all of that. What I'll tell you is it is some complicated mix of historic racism, poverty, current and previous prosecutorial philosophy, and frankly, a lack of connecting with the community. In order to actively, that's why we're supposed to live in the community that we prosecute in, because in order to actively prosecute, fairly, firmly, compassionately. You need to understand the community of which you're a part. One thing that I did when I declared for office, I went and had lunch with a number of members of the African American community to ask about their experience. It was important to me. I started my career in Baltimore City, where I represented predominantly young, poor African American males. And so to hear about an experience that I hadn't lived and know that the color of your shirt matters when you're arrested versus the color of my shirt matters is an important thing to understand. Now, Mr. Perry's right, it's about experience, but it's about the breadth as well as the depth of experience, which I have. I predominantly taught low-income African-American students in high school, understanding them going to school hungry, understanding the trauma which they were raised with, that you have to understand when prosecuting these people, firmly sometimes, compassionately others. It can be done together. Now, in order to actively look, you can't kind of look generally at everything. You need to treat each case fairly, but you have to understand what the collateral consequences are of each conviction and ask yourself, is doing something in the public interest? And in order to know what the public interest is, you have to communicate with the public. So the breadth of my experience has allowed me to not have blinders when dealing with these sort of issues. Thank you.
Thank you very much to both of you. Now a question about cash bail bonds. Virginia uses cash bail bonds for defendants who are awaiting trial, even if the charges would not typically involve a jail sentence. These bonds are usually set at what can be thousands of dollars. If a defendant does not have the funds to either pay a bail bondsman or to pay the cash bail bond themselves, then they're jailed while they await their trial. This can create disparities in the justice system between those who can pay and those who can't. Some criminal justice experts advocate for increased use of pretrial supervision. Some Virginia prosecutors no longer set a cash bond if the defendant is not deemed to be dangerous or a flight risk. What are your views on the cash bail bond system, and what would guide your practice if elected? So again, alternating, we'll start with you, Mr. Baber, and then to Mr. Perry.
So the cash bond system, bail, is antiquated, it's usurious, it's unfair, it's ineffective. The question is whether someone's a danger to the public or themselves, or whether they're a flight risk. That's the question. You're not a $10,000 danger to the community. You're a danger or you're not. You're not a $10,000 flight risk. You are or you're not. So either you are held in jail so your charges can be heard, or you're released to some sort of community-based supervision, of which we have great supervision in Staunton. Blue Ridge Court Services, which I've worked with my entire career here so far, is a fantastic organization, and like all fantastic government organizations, terribly underfunded. One thing I'd like to do is look for more grant money for my partnership organizations to be able to achieve my vision of assisting more people in getting the help they need pre-trial. There's an integral period from arrest to the first trial date, which is about 5-6 weeks. A lot can happen positively in somebody's life. That's my prosecutorial philosophy, and that is something that I wear on my sleeve as far as what I think is fair, right, and just about who should be held pre-trial and who shouldn't. Now, I like to give everyone a chance, except the most dangerous, which are held to start with. They get out, they have to check in, they are drug tested, they can start with a leg up and some services, and we see if they mess up or not. They come back, we can either set them straight, or then they get incarcerated until trial. So people get a chance, and they would get more of a chance in my office where public safety could be improved, not threatened in any way. But a lot of poor people are put in jail long enough to lose their job, their housing, their car, etc., just enough to set them back and cause the cycle to start all over again. I always take that into account. And every time I see someone come to court in a Burger King shirt, I think about that when it's time to let them out or not. Thank you.
Thank you. Our office does not seek cash bonds or secured bonds. the question is whether a person who is charged with a serious enough offense to be held in the first place by the magistrate, because that's where we become involved. Please understand, the vast majority of cases, a magistrate has already either released the person or they are released on a summons. The subset of cases where the prosecutor and the defense attorney are arguing before the judge about bond is actually very small. We're talking about a small subset of cases where the magistrate has deemed it appropriate to hold that person. All right? And in those cases, when we're talking to the judge, when we're making our arguments to the judge, we're presenting evidence, the question is, should that person be held, or can they safely be released to the community pending trial? So Mr. Baber's correct about that. That is the calculus for the judge. And our office has not been asking for cash bonds or secured bonds, and the reason is because, you know, if somebody puts up $500 or pays a bondsman $500 to get out of jail, that $500 is not going to stop them if they want to take off, if they're a flight risk, or if they're going to hurt the victim. That $500 is not going to stop them from doing that. So the question is, should they be held or should they be released? And if we look at the factors and set out in statutes for that, the circumstances of the offense, the nature of the offense, their history, whether a gun was used, the threat to the victim, whether they pose a threat to the community, whether they pose a flight risk, whether they have a history of failing to appear. These are all the factors we look at in the statute. Again, we're talking about a small subset of cases where that person was held by the magistrate and then we're arguing in front of the judge about that. We have great pretrial supervision services through Blue Ridge Court Services that includes HEN or ankle monitor for people who might be a flight risk or might be a threat to the victim. And so, you know, cash bonds, secure bonds are something our office has not been seeking, and I would not, certainly not as a policy, want to be looking at.
Thank you both for that. Commonwealth attorneys have considerable leeway in making decisions on how to treat certain cases with long-lasting impact. We want to move to a series of questions on how you might use your prosecutorial discretion if you are elected. Prosecutors often have discretion regarding whether to charge a young criminal suspect as they're either juveniles or transferring their cases to circuit court where they're charged as an adult and where conviction carries heavy penalties, including the possibility that it could lead to a life in the criminal legal system. What are your views on charging juveniles as adults, as well as your more important general approach in incarcerating juveniles? We'll start with you, Mr. Perry. Yes, sir.
Well, I've since I started this position in 2018, I've been in the juvenile court here at Staunton that entire time. For 7.5 years, I've worked in that court. I worked very closely with not only the other attorneys that practice in that court, but with the court services unit, who do great work. And it really is a collaborative job in working with the court services unit, working with guardians ad litem, working with the attorneys to try to figure out what is best for this juvenile, because that is the calculus in juvenile court. What is best for this child? Obviously, as prosecutors, we also have to look at public safety. We have to look at the well-being of the community. But the Code of Virginia says the welfare of the child, the well-being of the child is what drives everything in that court. Every decision we make, and even in serious cases, is driven by that criteria. And I've practiced in that court, and I have, in some occasions, transferred juveniles into circuit court to be tried as adults. Those are, and I can count on one hand the number of times I've done that. I'm not going to give specifics about those cases because of the sensitivity, but rest assured those are the most serious cases, and cases where that particular juvenile had a history, had already been through the juvenile court system. And we reached a point where the scale tips toward public safety, and we have to look at other options other than trying to rehabilitate that child in the juvenile court system. Now, there are still rehabilitative options in the adult court system, right? So you make that decision very carefully, but the vast majority of time in juvenile court, you work with all of the partners we work with to try to help the child, keep them out of the system, avoid incarceration. We bend over backwards in that court to try to keep kids out of detention, keep kids away from commitment to DJJ. We do everything we can to try to get them the help they need, the services they need, and I've been doing that work for the last 7.5 years.
The point of the juvenile system is rehabilitation. That's why we call juveniles that are in the system respondents, not defendants, because they're responding to charges against them. At this point, we don't even refer to them by a criminal word, and the whole point is to get them to a place where they can be rehabilitated before they turn 18. The brains aren't even fully formed yet. So as far as transferring charges up, I've never done that. I'll tell you why I've never done that. Because in Staunton, they have one position that handles all the juvenile stuff. Mr. Perry's held it. I've done everything else. General District Court, Circuit Court. I've done a fair amount of juvenile and domestic relations work in Waynesboro, where they divvy up all the work. But what I can tell you is, you have to consider the needs of the child. You have to consider the public interest. How do you consider the public interest? Get to know the public. And only in the most serious cases would you think about transferring a case up. A murder, a robbery, a rape, probably just a murder or a rape. The most serious of cases, where you go from a place of rehabilitation to one of just criminal accountability, you're always considering the metric of rehabilitation versus protecting the public. But the percentage kind of changes when you send someone up. You're also, when you send a juvenile to adult court, you are giving them lifelong consequences before their brain has been able to form. I know, I taught juveniles with those mushy brains, and that's a medical term. It's important to know, to have empathy, to understand for who it is that you're prosecuting in order to do the fairest job, the most just job for the juvenile and the community. And that's where a lot of those relationships can work with the community as well as with the parents and with the entire supervising court system. Thank you.
Thank you. So conviction for many crimes in Virginia carries mandatory minimum prison sentences. And prosecutors can use their discretion on whether to charge the defendant with one of those crimes or may offer a plea agreement that has a lesser penalty. Charging decisions can therefore have the effect of influencing defendants' choice to use the right to contest their innocence in court if they're going to therefore risk a tougher sentence. How might you use your discretion when making charging decisions to give defendants a more meaningful chance to contest their cases without risking long mandatory minimum prison sentences? And again,
I'm going to give you the most lawyerly answer ever. It depends. Now, what does it depend on? A multitude of factors. Crimes are not ones and zeros. We're talking about people here. So charging decisions are on a case-by-case basis. Ethically, you should never bring charges for which the facts and the law do not bear out. I think a huge part of this comes down to transparency. How do you make sure that the court system is transparent? Because a transparent court system is a fair court system. That's why we do everything in public and open court, not in backroom deals. And you can start that from the very beginning by charging appropriately for what the facts deserve, getting all the evidence or discovery in the most prompt manner possible to the defense attorney when it's appointed or hired, but not waiting until the very end. No gamesmanship on evidence. The case is the case. And to be able to present all of that, have meaningful discussions, have court hearings where you have the hearing on the record, communicate with your victims and other stakeholders, police, all your investigators, and make sure that at every step you are listening to the other parties as well as reflecting back on, do the facts actually support these charges? At the very end, that's a lot where kind of mitigating evidence can come into play. Assault and battery on a law enforcement officer carries a 6-month mandatory minimum. It's a felony. However, if you change that to attempted assault and battery on a law enforcement officer, or just assault and battery, it suddenly doesn't. Why would you do that? The difference is someone punching a police officer and having a mental health crisis and flailing and hitting a police officer. It's the same act, however, it's a different outcome, and there sometimes is a charging difference you can make which can meaningfully impact somebody's life and whether they lose their housing and what sort of living they're allowed to have. Thank you.
So an important part of this job is modesty. And by that I mean, the job of the prosecutor is not to make the law or to make policy, it is to enforce the law. I think it is very important for anybody who's in this position, whether they're the elected or whether they're an assistant, to recognize that they are not reshaping the law in this position. We follow the law that the legislature creates. And part of that does include mandatory minimums. And so there are a lot of offenses in Virginia that carry some form of mandatory minimum. In my practice, the cases I see that carry those kinds of mandatory minimums, child pornography, child solicitation, those kinds of things where the legislature has saw fit, and in my opinion correctly in those cases, to say that if you are convicted of this kind of offense, then there must be some period of incarceration. Now that being said, and kind of back to my point about modesty, we also should recognize that every case is individual and use our judgment and our discretion to make sure that we get an appropriate result. Somebody who has no record, who might be facing a mandatory minimum, you might decide in that particular case that that person does not need to go away for that amount of time. Maybe probation is appropriate in that case. Some cases you might say even taking the charge under advisement. I've had cases where a person was charged with an offense that could carry a mandatory minimum, but I used my discretion and said, that wasn't appropriate there. Probation is appropriate, or even taking the charge under advisement might be appropriate. You make that kind of judgment in every case. I think it's wrong for a prosecutor to categorically reject mandatory minimums, just as it's wrong for a prosecutor to say, I'm not going to prosecute a certain type of offense. Because that's not our job. Our job is not to make the laws, to enforce the law. But again, judgment has to be applied in every case, and judgment comes only from experience, and that is what I bring to the office.
Thank you both. Historically, if you've ever been convicted or accepted a plea agreement of any crime in Virginia, you could never have those charges removed from your criminal record, no matter how long ago the offense was, how young you were at the time, or how minor the offense. Yet criminal background checks are common when people apply for jobs, schools, housing, and even loans. In 2021, lawmakers agreed to the Clean House State reforms. These reforms would allow records, in some cases, to be sealed in order to improve access to housing, employment, and other opportunities. The records for some charges will automatically be sealed after a number of years. In other cases, Commonwealth attorneys can use their discretion. In particular, Commonwealth attorneys can use their discretion to change charges of those who deferred dismissal expunged as soon as they have specified conditions such as community service. They can also use their discretion in agreeing to seal the records of others who petition the court. What are your views on expungement? What values and goals would guide your decision? And we'll start with you, Mr. Perry.
So you're correct that in relatively recent years, the legislature has expanded expungement in Virginia and also has enacted new laws about sealing convictions. So even if you're convicted of something, it's a perfectly valid conviction, in some cases you have the right to have that sealed down the road. If you've been of good behavior, you haven't broken the law, you haven't been back into the court system for anything, you can petition the court to have that conviction sealed. Our office has a role in that. We can oppose that in given cases, or we can agree with it. It really depends on the particular case. And it is incumbent upon us to be familiar with the case, to look into it if we don't know the facts of the case, and to take a position that is consistent with the interest of the community. I will say that it's also true that there's a lot of limitations when it comes to sealing. A lot of convictions simply don't qualify. The more violent convictions, sexual assault, for example, any kind of felony sexual assault, that can't be sealed, and in my view, with good reason. That's the kind of thing that shouldn't be sealed. Our office has a role in dealing with expungement, whether we agree with a petition or oppose a petition. And in particular cases, I have agreed with petitions that came across my desk, and in other cases I've opposed it. Again, it's case by case, and your role as a prosecutor is to do your due diligence, to look at that particular case, and to make the best decision you can in the interest of the community. Again, you ultimately serve the community. Your job and your duty is to serve the best interest of the community, and my belief is that public safety really is the main primary duty of the prosecutor. So every decision should be informed by that. But to answer your question, that is a new responsibility for our office, a responsibility that we take very seriously. We have an attorney in the office presently whose primary job is working on that kind of thing, and he's very good at it.
I think Mr. Perry and I have different definitions of what public safety is. I think I have the idea of it's a bad guy in jail and everyone knows, or a scarlet letter on someone so everyone knows to stay away from him when he's out. There's another part to public safety, which is people's ability to move forward meaningfully in their life with housing, with employment, with getting services that they need. And expungement can really factor into a lot of that. Something that happened, we just talked about juveniles, maybe you just turned 18, you did something, and it's affecting you when you're 40. You know, one felony charge, let's say drug possession or something, turns into a life sentence. One felony theft turns into a life sentence when it comes to jobs or employment. And you have to look at the disparate effects of how that treats different races and income classes, people that need mental health services, etc. And in order to do that, in order to evaluate, should things be expunged, what's getting sealed on a record, are they a danger anymore? Do they need the help? You need someone that knows people. Community's a buzzword, but the answer is you have to speak to the people. You have to interact with the people. You have to be open to the people, and you have to constantly be willing to answer to the people for the decisions that you make. Now, again, I know people. A breadth of experience gives you a worldview to look at something like expungements and has somebody changed? What troubles are they facing now based on an old conviction, and be able to make the right decision and then look everyone in the community in the eye and say, I'm making this decision because you've trusted me to do what's best in the public interest. And in order to gain that trust, you need to show them who you are. And I'm standing here at my website by meeting you, and I show you who I am. Thank you.
Okay, thank you both again. And we picked up on some of these issues that have already been arising, but we did have a number of questions that were about giving your thoughts on some of the various programs that offer alternative pathways towards justice, and also that further explored your views on balancing the need to protect public safety with offering defendants the opportunity to rehabilitate themselves, as well as the amount of public resources that indeed are used in court and jail costs. So in many Virginia jurisdictions, including Augusta County, and I think you sort of were alluding to some of this earlier, including Augusta County, the Office of the Commonwealth Attorney has created pre-charging diversion programs to provide individuals with alternatives to fines, criminal prosecution, when it's possible. Individuals are given the opportunity to enter treatment for substance abuse and or mental health issues instead of facing criminal charges. So I guess we're curious, and it'd be interesting to know more about what's going on with these, because you were talking about them earlier, but I think we weren't aware of them. So what are your views on such pre-charging diversion initiatives, and would you consider developing them for Staunton, was what we were going to ask, but what are your thoughts about them, and why or why not use them? And so, again with you, Mr. Baker.
So what's being referred to is the Pathways program, which is something that Augusta County uses. It's a pre-charge diversion program. And just a brief primer how that works is the police, when they catch somebody in Augusta County right now, can say, hey, this crime, this issue, we can pre-charge. Before I charge it, divert it into the Pathways program, get you help you need, we can rehabilitate you, do some community service, you can pick up litter, they have job placement and get you signed up for Medicaid, which concerningly is going to get a lot smaller. They can give a lot of services, which is really an amazing way to get in touch with the most vulnerable and then get them the help. I've met with the people that run the Pathways program as part of my campaign, because the campaign is not just shaking hands, kissing babies, it's meeting with the stakeholders and figuring out what works so you can hit the ground running. And I've also met with Augusta County, the Commonwealth Attorney's Office, about the same thing. Here's what I'll tell you. I'll tell you, for it to work for Staunton, you have to get legal representation involved. You have to ask the public defenders and appointed attorneys to get involved as well, which I believe means people need to be charged. However, you can deal with it pre-trial. So you can call it pre-trial diversion, because there is a coercive effect to the idea of an officer being a little king on the road and saying, do you want to accept a consequence now, or do you want to get charged now? Because doing community service is a consequence. And if you ask a person that in an altered mental state with maybe not great legal education, there's a coercive effect, and you have to make sure that someone's constitutional rights are protected at all times. However, I believe in the philosophy of it and would work with Pathways, if elected, to form something that reflects the values of the people of Staunton. And I believe the people of Staunton want everyone's constitutional rights protected at all times, while protecting the community and doing right by the community. Thank you.
So I don't have a problem with diversion in principle. It is done, for example, in the juvenile court. Where is that appropriate? If a juvenile is brought to juvenile intake and they have no history, they've never been to court before for anything, and it's a relatively minor offense, intake can divert that and say, we don't need to go into court. We can get this child services, we can get them connected with Valley or with other service providers and get them help rather than go through a formal legal process. I think that is appropriate in those kinds of cases and in a fairly small subset of cases. When we're talking about pre-charge diversion, which is what Pathways program is, what the question was about, I actually share the concern that John conveyed, that I think that pre-charge diversion, where somebody isn't charged, doesn't go to court, doesn't get legal representation, I think that can be a little bit difficult. In Staunton, we have developed over the years, and going back to years and decades before I came here or John came here, we developed alternative programs, recovery court, therapeutic docket, these kinds of programs where somebody has legal representation, they consulted with their attorney, and their attorney has negotiated with the prosecutor some kind of alternative to incarceration or even a conviction. We take charges under advisement all the time, so that person avoids a conviction. They get referred to probation where they can get services. Or recovery court, a great program. Therapeutic docket, a great program. All of those are run by Blue Ridge Court Service, which does a great job. For those programs to work, though, you have to have a prosecutor who is charging cases and enforcing the law. If somebody is charged with drug possession and they know that they won't be convicted or they'll be given a misdemeanor and sent on their way, why would they do recovery court? So we have a very healthy system here that has developed over the years. We have to use it.
Thank you both. Many Commonwealth attorneys are creating specialty dockets for certain court sessions that offer a therapeutically oriented judicial supervision of treatment plans with special service providers. There are behavioral health dockets, recovery courts, and specialty dockets for veterans with PTSD or mental health or other mental health or substance abuse struggles related to their service to our country. What are your views on such specialty dockets? What would you seek to create them for Staunton? Would you seek to create them for Staunton if elected? And we'll start with you, Mr. Perry.
Thank you. So I just referred to those dockets, recovery court, therapeutic docket. Both of those are fantastic. Both of those are created by the legislature, and they don't just exist here in Staunton, but all over the state. They are the creatures of legislatures. The legislature saw fit to create these alternative dockets or specialty dockets, as you said, and they are great. People have to use them. If there's a problem with recovery court therapeutic dockets, it's that they're underutilized. We don't have enough people going to them. Now, you have to be careful about the people that you send there. They have to be appropriate for it. And if it's recovery court, for example, you have to be somebody that recognizes they need that level of help, and they're willing to go through that. It's an intensive program. Same for therapeutic docket. It has to be somebody that has a diagnosis that meets the criteria for that program, and they have to be willing to go through it. I've sent people to therapeutic docket, and they've completed it, and they are different people on the other end of that. But again, the role of the prosecutor, number one, is to make sure that we are enforcing the law so that people actually have an incentive to use those specialty dockets, and two, to make sure that the right people are going to them. To answer your question about other specialty dockets or veterans, I know those exist in other parts of the state. I know there's one in Northern Virginia. I would be open to that. There may be overlap with therapeutic docket, but I'm absolutely open to considering any other kind of specialty dockets. I will say, my position is that, again, going back to what I said about modesty in this office, it has to be something created by the legislature for us to do it.
Again, I think there's a bit of a philosophical difference on what the role of the prosecutor is. I believe it's of a leader that represents the interest of the community, and you know because you've asked the community. So there's a fair amount of discretion given, not just charging, prosecuting, going to court, it's connecting. It is getting with service providers and figuring out how to better get people to the place that can best assist them. All of that can be done through the court system, not with any kind of fancy, new made-up law or deciding not to prosecute something. It can all be done. It's just an idea of philosophy and motivation. I tell people when I campaign, I'm old enough to have the experience, I'm young enough to have the energy to do this job. And that's really important. I passionately care about everyone in this community, especially the most underrepresented. And the idea of a specialty docket is to assist them. We have some great ones here. The therapeutic docket is a fantastic docket. I think a lot of how much you help versus punish people has to do with a philosophy of the office. And that philosophy comes from the top, comes from vision and leadership. I've presented mine to you clearly. I think Mr. Perry has as well, about who's interested in using the discretion, the power vested to do the job, to assist the entire community versus who's interested in the consequences alone. And I think as well with specialty dockets that they can be a powerful tool to motivate people. However, they are still part of the court system with onerous consequences if you don't obey. And I think a injection of compassion into all of it is necessary in order to reflect the compassion of the society that we live in Staunton. Additionally, you can lead more people to the answer if you tell them you want to get them help first, not do this or else. Thank you.
Okay, so now we'd like to hear your all's views on restorative justice as a slightly parallel paradigm to justice seeking that focuses on repairing the harm that a criminal offense has caused directly to the victims, both directly and indirectly, as well as the broader communities. In some Virginia jurisdictions, the Commonwealth's attorney allows juvenile and nonviolent offenders of all ages to voluntarily engage in a specialized mediated restorative justice process where victims and others who are affected share their stories about the impact of what happened and can ask for what they need of the offender. The offender acknowledges the harm caused, and the participants can decide a plan for how best to repair the damage. A lot of research reveals that in general, those who have been actually harmed by a crime often in these cases report greater satisfaction with the outcomes as well as reduced levels of fear. Offenders who are held accountable and often undergo significant change from the experience. some of these programs, the defender accepts responsibility for wrongdoing, but is not actually charged or prosecuted. In other restorative justice programs, the defendant is charged, but then diverted pre-conviction into local services that are supervised by the court. So what is your all's view on these restorative justice programs, and what would be your considerations for their use in Staunton? Mr. Baber, we'll begin with you.
I love them. To start, I think there's been one, it's said, local news, one TV interview when Mr. Perry and I announced, and the only sound clip they used of mine was saying, I'd like to do restorative justice. I'd like to do community mediation in Staunton. That's the part they picked that they thought was noteworthy. So I've said this since the beginning. I think things where you can bring community members together in a supervised way in order to process damage and help healing are hugely important to making sure that a lot of these issues don't happen again. Now, I believe everything, in my opinion, should be done if it comes through the court system post-charge in order to adequately protect somebody's rights. It is tough, especially most people that come through are lower income. They need an appointed attorney or a public defender to face them with a consequence or to have meaningful participation without making sure that, first of all, the charge bears it. And that can be done through somebody having an attorney. However, pre-trial diversion, where they've been charged but not yet convicted, can be hugely powerful to healing. Now, I'm going to give a little anecdote. There was a case I know of where two property owners, adjacent property owners, had multiple disputes and ended up in a pair of trespassing charges over a property boundary. Those people aren't moving, and the problem will continue whether or not you convict people of trespassing. That was a beautiful case to refer to community mediation. Oh, it doesn't formally exist. So I was able to cobble something together. If elected, I would create a community mediation system. I would do so without asking for any additional resources. I can do more with the resources the Commonwealth Attorney has. Motivation and connecting with those people that provide these resources. And that comes through understanding them, being able to connect with people honestly and humbly, asking and leading. Thank you.
So how many people here know that we had a restorative justice program in Staunton about 20, 25 years ago? Have some people that remember that? Jeff does. Before my time, we had a program, restorative justice program in Staunton. It may have been Augusta and Waynesburg as well. Again, Staunton, Augusta, Waynesburg always been a little bit on the cutting edge. And back 20, 25 years ago, restorative justice was all the rage in criminal justice, not just in Virginia, but in the country. And as you've identified, what restorative justice roughly means is getting the victim together with the offender or the perpetrator and figuring out how to make that victim whole, holding the offender accountable, mediating what happened between the two of them. We had that program here. It lasted for a few years. I spoke at length with the person who was the director of the program initially, Kathy Jenkins. She has endorsed me. She is a victim advocate. She's worked in all different parts of the court system. She's now the domestic violence program coordinator for State and Augusta. And she and I spoke at length about that program. It was a good program. And for the right type of offense, it was great. You know, that kind of offense where you had two neighbors having a dispute, or a juvenile knocks over, their neighbor's mailbox. That kind of thing. It's a relatively small set of cases where it really would be appropriate. And the reason for that is, number one, you're not talking about violent offenses. In my judgment, you're not, that kind of offense, a violent offense, would not be appropriate for restorative justice. We're talking about lower level property crime. My concern in looking at something like that would be, do we have the volume of that and stand to support that kind of program? I would absolutely be open to it. The one thing Kathy said to me was, in those cases where it was right, it was great. It could have been it was a great thing for the victims, great thing for the offender. Do we have the volume of that? I'd have to look at it.
Thank you both. The Trump administration has signaled its intentions to harness local law enforcement and titles around the country to support its campaign against legal immigration. If you were Staunton's Commonwealth attorney, what legal considerations would influence your advice to Staunton's law enforcement agencies, and in what way would they incorporate with the U.S. Immigration and Customs Enforcement Agency, also known as ICE? And we'll start with you, Mr. Perry.
Well, the short answer is that should be a question directed at the police department. Our role as the Commonwealth's attorney is to prosecute offenses, is to work with the police department to prosecute cases that come before us. We're not offering general legal advice to the police. What I can say is I have worked very closely over the last 7.5 years with the police department here. We have a very good police department in Staunton. I've worked with a lot of different law enforcement agencies in my career. The Staunton Police Department is highly professional, they're accredited, good officers work there. I have every faith that they would use their judgment to do the right thing in that case. I don't think any local police department is going to want to be bear down upon by the federal authorities. You have to follow the law, right? But is our local police department going to be conscripted? No, I don't think that's going to happen. As a prosecutor, what is our role to address these kinds of concerns? Again, it's to use our judgment in every case that comes before us to do the right thing. I've had cases where an individual might have had immigration concerns, and I have taken that into account in what the disposition was. I think that's the appropriate role of the prosecutor in those cases. We're not going to be able to fix what's going on in Washington. We're not going to be able to address what ICE is doing. I understand a lot of community members are concerned about that, or upset, worried about their neighbors. I'm absolutely sympathetic to that. There's only so much the Commonwealth attorney can do when it comes to that, and if anybody tells you differently, they're not being forthright.
Kind of sets me up when I tell you differently. Now, I won't really disagree with some of the substance of what Mr. Perry said. To start, I will tell you, the Commonwealth attorney is the chief law enforcement official in the jurisdiction. They're vested with a huge amount of power. It's a constitutional office. They actually don't have a boss. Well, they do. You. Now, that's separate from the police department. Police department has an appointed police chief. They answer to the people of Staunton just as well. They answer to city council. This is a question that is for the community, not just our office. However, our office is a stakeholder and a protector of public safety. Now, police officers charge state crimes that happen in the city of Staunton. Staunton police officers charge state crimes that happen in the city of Staunton. What we're talking about is enforcement of federal laws in the city of Staunton. So already there's a bit of a jurisdictional issue. And what's needed, I think, is a community conversation involving all stakeholders, including city council, that the Commonwealth attorney is happy to engage in about what is to be done. The wait and see approach, being reactive, is not my philosophy, rather proactive. And how do you be proactive but honor the law that exists and the people that elected you? Tell them what you're thinking. Tell them publicly. Engage with city council. Go to the meetings. Talk to the police. And listen. Again, I believe firmly in upholding the law in the state of Virginia. However, at the same time, the reason I'm running as an independent is because Lady Justice wears a blindfold for a reason. People are supposed to get a fair shake in court, and you're supposed to represent the idea that everyone gets treated fairly under the Constitution, even if larger powers maybe don't think so anymore. And so there's no large signal to be made. I'm certainly not one for grandstanding. What I'll tell you is you have to connect with the community and be transparent and open. Thank you.
Great, thank you very much to both of you. Those are the questions that Building Bridges had formed. So now we want to turn to you all, and there's a lot of you, and what we're going to do is actually, it's helpful to have We can, yes, that's what we can do, because I think it's going to be hard for people to get up in here in the middle. So what we're going to do is, we're going to end our forum at 7:30 tonight, and we do want to give both Mr. Baber and Mr. Perry a chance to have 2 minutes each for closing remarks. So we will just take questions until they have finished up, and then, but please, if you can keep your questions short, so we have time for plenty of questions, and then we'll give 1 minute response to each. If it looks like do you have any sense of how many questions we're going to have? Because then we can have a bit more time. I see. Maybe we can do 2. We might be able to get away with 2 minutes each. Just try to keep it quick. So maybe because you're right here, so it's easy for me to get you first, and to you, and then.
As background for this question, I've worked at Blue Ridge Legal Services for the last 45 years, and we often see elderly clients who are very frail and vulnerable, who have been taken advantage of by people who exploit them financially. And over the years, we've had some regrettable experiences in trying to get law enforcement to take these cases as a criminal case. We've had some success with that, but we've had a few frustrations. So I'd be very interested in knowing how you as Commonwealth Attorney would approach those cases.
Should we just keep our
I forgot
rhythm? I think that you finished up last time, so Mr. Perry, I think you would be first this time, and we'll just keep that alternating pattern going, if that's okay with you all.
So I've prosecuted a number of APS cases, adult protective services cases that come through Staunton. We have regular MDT meetings, multidisciplinary team meetings with APS, with actually somebody from your office, as well as a doctor from Augusta Health that can offer their perspective on issues like vulnerability of older adults, whether they might be, people that might be exploitable by defendants. So we have regular MDTs for that, and we discuss these cases. In my experience, Staunton PD takes these cases very seriously. We have investigated and charged. I've charged a lot of them and prosecuted a lot of them. In most cases, it is a family member that is doing the exploitation. And those cases can be very difficult because what you often find is by the time you get to court, the victim of that case does not want to see their family member prosecuted. And you have a difficult case on your hands. But I have prosecuted those cases. Lindsay Combs, who is the APS director, she's supporting my campaign because she's seen how hard I work on those cases, how hard I take, how seriously I take exploitation, not just of vulnerable adults, but certainly children and anybody else in our community who is vulnerable and defenseless. I think those are the worst kinds of cases. And I think there should be given the attention and resources to the prosecutor and the police department, and we do. We have regular NDTs. We talk about those cases regularly. They can be difficult for a number of reasons, and I've had some very difficult ones. I had one where it was a lady who was operating essentially a kind of a assisted living facility that was not licensed, and I worked very hard and very closely with an attorney from your office in prosecuting and getting appropriate results in that case. So to answer your question, if I'm elected, we would take those cases very seriously.
I gotta tell you, I've knocked doors in some of the biggest neighborhoods, Hillcrest being one of them, and so many older people answered the door, and many were excited to talk to me. One, because I was the first person knocked on the door for a while, but two, many were a little bit lonely. And that's the recipe to start for one of these cases. Physical abuse, financial abuse. One serious case I had in Staunton, an older woman worked as a nurse at Western State, the old Western State. A caretaker, she thought was going to take care of her later in life, opened credit cards in her name, spent $60,000 and left her high and dry with all the bills. We took that case to trial, had the person prosecuted, convicted. I wrote credit card companies and said, we're criminally charging this case. This is fraud. Erase this debt. And they did. We got restitution for the rest of the amount that couldn't be erased. And the woman has now gotten all of her restitution. The offender as well has been tagged as an embezzler. And this was not just a terrible crime because of how it happened, but the emotional component. The older victim felt like her own daughter had just betrayed her in her later years. I take that stuff really seriously. I loved my grandparents. My parents are now grandparents. Only one taking their money is me. That's just a joke. They deserve the dignity of being safe. And when they are victims of crimes, physically, financially, neglect, you have to treat those people with the dignity they deserve as well, because many of those people later in life, the idea that they've been made so vulnerable is so weakening for them. It hurts their pride when they've lived a fair and hardworking life, and I have the philosophy and affect, the care, in order to deal with those cases. I think they're very important. Thank you.
So unfortunately, both of you know me. I've worked with both of you. I've been a prosecutor in Staunton for 6 years. We have some very talented defense attorneys who are giving me dirty looks right now. They're very skilled, and part of the Commonwealth attorney's job is keeping citizens safe. It's trying cases. It's taking cases to trial. These very talented people say, I don't like your offer. What are you going to do? So my question for you, we've worked with under Mr. Gaines, we've worked under prior to that Mr. Robertson, who had extensive trial experience. When push comes to shove, when programs aren't the answer, what kind of trial experience do both of you have? How many jury trials have you put on? What kinds of cases have you taken to jury trials? What kinds of results have you had as the lead attorney on the toughest of cases? Again, these fine attorneys make you put on. Thanks a lot for that, by the way.
We're continuing the alternating pattern, so I think it's Mr. Baber next, and then we'll Mr. Baird.
So I worked with Matt Falwell. Matt also drove Joe's truck in the 4th of July parade. So nice to see you again. I've had extensive trial experience. I believe trials are the cornerstone of the justice system because they take place in public under certain rules. That's what gives that transparency. This is not the Star Chamber. That feeling of fairness. In Baltimore City, I got probably 20 years of experience in 5. It's fast moving, it's huge, trials all the time. Here in Staunton, it's a little slower, thank goodness, for all of us. Some of my most important trials here, again, I mentioned, was the one case with the embezzlement and financial exploitation, very important trial. Multiple trials involving drug dealers, complex electronic evidence in some of these trials as people do more and more of their business using the internet, or cell phones have become more important. Multiple. I could even say probably hundreds of DUIs, which I call the murders of district court. Everyone's an attempted murder, every DUI. You could kill someone, and those trials are pretty important. They're very important to public safety. So it's not just the big trials, it's the mundane, where you give someone, the defendant, their day in court. And the important part of a trial is it's part of procedural justice. When you put out all the evidence, where you prove all the case according to the rules of procedure and the law, and you ask the judge and the jury to decide beyond a reasonable doubt the case. However it sorts out, and for me it's more often, I wouldn't call it winning and losing, but rather that justice is done. However it sorts out when you do the full trial, that's what's most important, that's procedural justice. So I think it's very important. Thank you.
Thank you. So I, in my career, I've been a prosecutor for about 15 years now, for 7.5 years in Staunton. I've done over 30 jury trials. Jury trials are the most difficult thing that you do as a prosecutor because obviously you have the full force and effect of the defense attorney on the other side, doing everything they can to get the best result for their client. But you have to convince 12 people of the community to agree on something. Getting 12 people to agree on where to go to lunch is difficult, much less to find somebody guilty of a serious crime. And the more serious the crime, the harder it is to get 12 people to agree. In my time here at Staunton as chief deputy, I've prosecuted a number of felony sexual assault cases all the way to jury trial. I've gotten some good results, some less good results. Those are hard cases. The vast majority of the time, the case hinges on the testimony of a child, and juries have a harder time finding a man or a woman guilty beyond a reasonable doubt when the bulk of the case is the testimony of a child. But I'm not afraid to take those to trial. I know those are difficult cases. I know they are uphill battles. But I believe that the prosecutor must be willing to take a case to trial, even if the odds are long. If you believe the defendant committed a crime, you believe it beyond a reasonable doubt, you must be willing to take that case to trial. And I've done that time and time again for victims in this community. Over 30 jury trials in my career, countless bench trials. My opponent just does not have that kind of experience. That's a critical difference between the two of us. And I think that people of Staunton deserve a prosecutor, a Commonwealth attorney, who has the experience trying the most difficult cases to trial.
I want to do just a little bit of a time check. I see you have a question right here, and then I'll start moving back, and Shasania's doing that side. Let's see how many people are wanting to ask questions, because we might drop the length of response time down to 1 minute so that there's enough for everyone. Can you just hold up your hand if you have a question? So 1, 2, 3, 4, 5, 6. I think we'll drop the time down to 1 minute per question, if that's okay now. Okay.
I'm a student at State High School, and I've consistently seen my peers in and out of the juvenile system. So I was wondering what further prevention of rehabilitation is going to help, since the juveniles and peers of my age are the future of America and our city.
Thank you. My turn. Okay.
Yeah, please, sorry. I'm sorry.
I didn't want to jump in.
Yeah, no, my apologies. I was starting to look at the next question to line up. Yes, please, if you just continue the alternate
All right,
pattern.
start
Yeah.
the clock there. So again, in the entire time I've been here, I've handled almost every juvenile case that's come through Staunton. I tell people, if it involves a person under the age of 18, whether they are a victim or whether they are themselves court involved, I am the attorney that handles that. Whether it be a truancy issue, all the way up to a child who is a victim in a serious felony case. We have juveniles that are court involved because they themselves have been involved in a serious offense. Every juvenile case that comes through Staunton, I've dealt with. I've worked closely with our court services unit to try to get the right result in every case. Again, we endeavor in every case to avoid conviction, to avoid incarceration, to rehabilitate the child, and to address that child's specific needs. Again, whether it is a truancy case where that child is not coming to school for whatever reason, whether that child is dealing with mental health issues or substance abuse issues, or all the way up to that child has themselves committed a serious offense. In every case, we try to do right by that child and right by the community.
The first thing I think about with child cases, I think about my own child. I think it gives me a real perspective on how I would want the child to be treated in the system, be treated by society. Thank you for the question. Kids are the future. That's kind of a just general statement, but they also are the ones that are filling the roles and jobs that are eventually going to be caring for all of us and doing these jobs that we're standing up here asking you to do today. Somebody else is going to do, and we're going to protect them, and the teachers are going to teach them, the parents are going to parent them. One thing I understand intimately is the trauma caused by many children, or caused to children growing up, and how that trauma manifests itself in many ways. So my personal experience, the breadth of my experience in public service, again, the point of this job is a leadership role. We're not counting number of trials, we're counting who can best lead the office. And as such, I have the philosophy to lead, and part of that is putting people like kids first. Thank you.
Could you tell me, just share some thoughts on the children in Commonwealth Center and Liberty Point? They are all primarily from other jurisdictions or states. How would you handle the children who are in a mental health facility but are explaining criminal behaviors?
First, by connecting with all of the experts in order to best be educated about the child's issues. And I'll tell you, one thing I do as the elected Commonwealth attorney is I would make sure my staff, all of them, were appropriately trained to do this, to cycle through the juvenile system. I think it's really important that every attorney hired as an assistant Commonwealth attorney handle these sort of cases, that they're not siloed. Burnout happens, tunnel vision can happen, and experiences from other court systems can be brought in order to best help these people. So I think taking a broad and compassionate view of criminal behaviors from mentally ill children that happen in our jurisdiction through these centers is important, to remember that these are people who are struggling, but at the same time keeping the community safe. Staunton is a place where many sick people kind of get brought here in warehouse. That's what Western State was, and people have dignity. However, the people that work at those facilities who sometimes get affected have dignity too, and so there's a balancing act. But everyone in the office needs to be trained to deal with it. Thank you.
Thank you. So again, in my time here in Staunton, I've prosecuted those cases. I've handled those cases that have come through the system, and they are difficult because, and something I've struggled with. We have the Commonwealth Center here in Staunton. It is the only psychiatric hospital for juveniles, state psychiatric hospital for juveniles in the entire state. We receive every kid from across the state who might be in acute psychiatric crisis. They end up at the Commonwealth Center, and oftentimes they engage in violent behavior. So the question is, what do you do with them? I've struggled with those cases time and time again because we have people that are hurt by assaultive behavior, sometimes badly hurt. On the other hand, you have a child who is in a psychiatric hospital. What do you do? Generally, the answer for me is if that child comes to us from another jurisdiction in the state, adjudicate the case here, transfer it back. The code allows us to transfer it back to their home jurisdiction. Why do we do that? Because in my view, that place, that home jurisdiction, that judge, that court is best equipped to figure out what is best for that child.
This is going along with the outside law enforcement situation going on that we see on TV. And whose job is it to verify that if a man with a long gun and a mask comes into this community with I don't know what paperwork, who gets to look at that paperwork and who gets to identify that outside law enforcement agent when they don't have exposed credentials? Thank you.
And is this is a follow-up with the ICE? Okay, just to clarify.
Mr. Perry?
Right. So I think, it's incumbent upon the federal authorities to cooperate to that extent if they're going to be coming into our city to let us know, to let the police know, so they're not just showing up in masks and displaying guns. That's going to terrify people. That's going to terrify the entire community. It is incumbent upon them to coordinate and let local authorities know they're going to be here engaging in enforcement action. If we have issues with that in the community, I want members of the community to bring it to my attention so that I can have that conversation with the police department. I have developed a very strong relationship with our local police department over the years, and for that reason, they will listen to me if there are concerns about that. If people start to see that, if people start to hear about that in our community, bring it to our attention, and we can try to address it as well as we can. Again, I'm not standing before you making grand promises that I can do anything about what ICE might be doing in our community. I don't have that authority. But if there are concerns about that kind of behavior, that does concern the community, and that needs to be addressed. So I ask that people bring that to my attention. Thank you.
The Commonwealth Attorney is a partner in the community, along with law enforcement, city council, and the people themselves, along with many different stakeholders, service providers, and it's incumbent upon us all. Now, many people look to the Commonwealth Attorney as the chief law enforcement official. What I will tell you is that this is certainly issue nationwide, there is a fair amount of fear about the unknown, even covering people's faces they don't know. And then it goes back to an issue of non-transparency, which terrifies people, I think might be the point of it all. So in order to address that kind of hypothetical, training needs to be done. And everyone needs to be prepared for eventualities because you want to be proactive, not reactive. My time in the Commonwealth Attorney's Office in Staunton, I was the only one that ever went and trained the police on legal updates. I was the only one that did it, and it hasn't been done since I left, on obstruction of justice, on modern legal updates. Not sending a PowerPoint, training them. And I would resume that if I came back. Thank you.
Hello, gentlemen. Thank you for running. I have a question regarding the campaign literature that you handed out, and also to your reference to the Constitution, both in your literature and also tonight with the constitutional rights of people that are arrested. I was wondering which type of constitutional interpretation do each of you follow? One is the more current originalism, written for the 1780s, or our more current justice system, where we have a social contract, and it's called a living constitution. I think it's time to ask that question. Thank you.
I follow the actual Constitution that's borne out by the document itself, as well as established case law. The Constitution is hugely important, and it protects all of us. And the crazy thing about the Constitution is it gives a ton of rights to defendants, and that's an important thing that our founding fathers said about people in our country, that the worst of us deserve to be protected, so that all of us know if it ever came to be our turn, we would be too. I think John Adams ended up defending a bunch of British redcoats after the Boston Massacre, and he had to look everyone in the eye and said, hey, they deserve a good defense too. That's how you show everyone it works. That's the point of the Constitution. You have to, the prosecutor is transparent. The state must be stately at all times. And you are laying your cards on the table, and you're doing things by the book, and you're showing everyone this is why I'm doing it and why. And you're making sure that the other side has competent counsel and that you're staying within the rails at all times. So I believe in the actual Constitution. Thank you.
Well, that question sounded a lot like a question a senator might ask somebody who was being nominated for the Supreme Court. And sadly, I did not have the grades in law school to be in that position. To answer your question, I want to return to the point I made earlier about modesty. I think modesty is an important virtue in this office. And what I mean by that in this context is that I don't want an elected Commonwealth attorney who has some grand vision about the living Constitution versus originalism. We don't do that kind of work. We don't do appellate cases. We rely on appellate courts, whether it be the Court of Appeals of Virginia, the Virginia Supreme Court, the Fourth Circuit Court of Appeals, and ultimately the U.S. Supreme Court to interpret the law, and we follow that. We follow case law. We follow statutory law, and we follow case law. We may disagree with it. There may be cases where we say, I think they got that wrong. I would interpret it differently. It doesn't matter. We have to follow the rulings that come down from the courts.
Hi, my name is Stacy Falls. I'm a circuit court clerk here for Staunton. Our office handles over 800 statutory duties, so we do a lot of collaboration. Work very closely with the Commonwealth Attorney's Office. The Commonwealth Attorney's Office is responsible for working with many different agencies, to include law enforcement, clerk's offices, probation offices. What is your current working relationship with these agencies? And if elected, what is your plan to ensure there is a smooth transition so that the citizens of Staunton, to include the victims, are not negatively impacted by this change?
Thank you. So one of the honors of my life has been, since announcing my candidacy, the support I've had from various members of the community that I work with. My support in this campaign has come from people that I work with. That includes Stacy, who endorsed me. That includes members of the police department who are supporting me, other members of the court community that are supporting me. It is important that we have a good working relationship in this office with all the different agencies, not just the police department, but all the other different agencies that we work with, because it really is a collaborative job. And if I'm elected, our office would continue to have a good working relationship with your office, Stacy. We have, as you know, a number of duties that come through our office, whether it be concealed carry permits, expungement, sealing, which is becoming the sealing of the records that you talked about earlier, which is becoming an increasingly big part of what we do and what you all do. And our office would continue to work very closely with that. We also do a lot when it comes to restitution for crime victims, which your office deals a lot with and spends a lot of resources on. It is incumbent upon our office to work with you all very closely to make sure that victims get restitution.
I have a high respect for law enforcement who's not paid enough, asked to do too much. I have a great relationship with law enforcement because of that respect and the amount of time that I've spent supporting law enforcement, both teaching at police academies. Most kind of baby officers sent out to do a dangerous job, and I taught them the law part of being a law enforcement officer, as well as my time in Staunton, where I knew many officers, worked with them many cases, and gave them legal training and updates because I cared. No one asked me to. I saw an obstruction of justice case or not, or a Miranda issue that someone had a question with. I said, I bet everyone's got the question. I went and I did the training because I care. A smooth transition is paramount, but also growth doesn't happen in a spurt where it's not strong. What I'm offering is growth, not change, not something different. More is what I'm offering. More support for law enforcement, more trainings for law enforcement, more support in the community. And I'm adequately and uniquely prepared to be able to give that. Thank you.
I'm going to dovetail, my name's Shannon Harrington. I'm going to dovetail on what the gentleman across the way there had asked about, and that's ICE and ICE operations that are happening just to the north of us, not too far away. And, you know, I stood up at City Council the other night and asked about this too. And I know, as being a decently long resident here, that Chief Williams works very hard, Captain Brown works very hard, Sheriff Hartless works very hard. I know them personally, to develop a relationship with the community, with residents. I hear you both saying that that's important to you as well. And I also hear you saying that the protection of the public is important. My question is very specific, and it's this. Will you each be willing to stand up and say that we require the professionalism from ICE that we require from our local law enforcement? That means no masks. That means body cameras that are working. That means the proper paperwork and identifiable who they are showing up on their uniforms in the same way that our local law enforcement are required. Will you stand up for this community to say that we don't accept less than what our local trusted officials provide to us as leadership in law enforcement? Will you say that? Thank you.
I'm a member of the community and a lawyer and a leader. I'm not a politician. This is not a pulpit. I'm not standing here looking to make a grand declaration and put a target on this city. That's essentially what's being asked here. Are you ready to make a symbolic declaration and bring the wrath of the current administration down on us to prove a point again? I'll tell you this. Preparation, preparation, preparation. Being proactive, training everyone and making sure everyone is aware of how to do their job constitutionally, how to interact with different authorities, and how to handle that professionally. Again, this is why I'm running as an independent, is it's not a job for politics. This is a job about people. And so in order to keep the focus on the people, the safety of the community, you need prepared people. But at the same time, the people of Staunton are not a springboard to take a stand that I believe would be a grand statement with could be tough consequences that don't match whatever the words come out of you are. So discretion is always key in a prosecutor. Thank you.
So, Jan, your question was whether we would pledge to hold ICE to the same standard that the local police department is held to. I'm going to answer your question directly, and the answer is I cannot make that pledge. If I could, I would tell you that. If I were to tell you otherwise, I would not be telling you the truth. The fact is, we do not have control over the standards that apply to ICE. Now, what we're seeing in the country is that courts are applying standards, legislatures at the state level are applying standards. I know California recently passed a law that says you cannot, essentially you cannot wear a mask, really directed at ICE, targeted at ICE. If Virginia passed that law, we would follow it. But for me to tell you as a Commonwealth's attorney, or for any local official to tell you as a Commonwealth's attorney that we could somehow impose standards on a federal law enforcement agency, I cannot make that pledge because I don't have that power. We have a great police department here. They are at a very high level of standards, as you know, and it's an honor to work with them. I wish that ICE were held to their standards with body cams and everything else, but I cannot make you that pledge.
Okay. Thank you all for your questions. Thank you all for your engagement. And thank you especially to the two of you. We want to give you both a moment to just, maybe a moment to breathe. You had a tough pace tonight. But also just to round out the evening with your closing remarks, not necessarily the closing argument like you would do in a court trial, but really, what are the things that you would like to leave in people's minds tonight as we round up? And we're going to give 2 minutes to each for that. And I think that we began when we did the coin toss. I think you started. We were going to switch it. So the final one, am I right? I remember at Building Bridges Point that for the last one we were going to alternate that. So Mr. Baber, if you want to start, and then Mr. Perry, you can finish us.
I've done the work in this campaign. I've met the people because I care. It's about preparing to do the job. And the question is, what do you want out of this job? This is the first time in a generation where you get a say, where it's not just the next in line that takes over. And I think that's powerful. It's 2025. How do you want your Commonwealth Attorney's Office to look? Who do you want to run it? Whose vision do you trust? And so coming to something like this is really important in order to judge us both by our merits, by what we say, as well as do research into us, learn about who we are. Everything about me, you can learn and judge me as a person, and that will tell you how I'll be as a prosecutor. Part of what I tell people when I knock on the doors is, you now know what I look like. You can find me when you don't like what I did and tell me in my office or at the grocery store what you think, and I'll give you an appointment because I serve you. So again, my belief, my philosophy, violent people go to jail, but sick people need help. And that is more than a majority of the cases that come through the court system. We can do something more here. I'll give you everything that's been being done already as far as holding people accountable. And I'll give you more as far as services go to help those that are suffering break the cycle, heal the community, and public safety. And that's done, again, through my beliefs, my breadth of experience, my long-time commitment to public safety, as well as my own personal experiences, which I've told you about, and you can find all the information about me. I care about this community, I'm invested in this community, and I ask for your trust in allowing me to lead the office and do it in a way that you folks would like to see done. Thank you.
Thank you. So I appreciate everybody's time and attention, and if my voice is a little bit kind of weak here at the end, I've been in court all day, and that really is who I am. I go to court every day for the people of Staunton. I've worked tirelessly over the last 7.5 years for this community. I've done so because when I took that job, when Jeff offered me that job back in March of 2018, I took the job, I was sworn in. 2.5 years later, I became the chief deputy. I took an oath to uphold the law, and to represent the people of this community. And I've taken that job very seriously ever since. I've been committed to this community. I've worked very hard, day in and day out. John talks a lot about philosophy and vision. I don't talk about those things. I'm a pragmatic person. What I talk about is what I've done. I don't just talk about justice, I deliver it. I've done that day in and day out for the people of this community. I work very hard for victims, particularly vulnerable people in our community. My belief is that the job of the prosecutor is to protect his community. And I've done that. My focus has been on protecting children, and I've worked very hard at that. I've been so honored and blessed to work with some amazing people, not just in the police department, in probation, court services, the Children's Advocacy Center. My commitment has been to the city of Staunton. I'm not a politician, I'm a prosecutor, I'm a working attorney, and I think that is what the people of this community deserve in that office. Somebody with real experience dealing with the most difficult cases that we have, and I'm that attorney. I've prosecuted serious child abuse cases, homicide, robbery, dozens of felony sexual assault cases. Those are the hardest cases that we have, and this city deserves a prosecutor that has that degree of serious experience. You've heard my opponent. He doesn't have the trial experience that I do. I've tried over 30 jury trials. That is what this community deserves. Thank you.
Okay, and thank you to both of you. We really appreciate your participation and your a lot to run for public office, and we appreciate you all doing it. I'd also like to express appreciation on behalf of Building Bridges for the Greater Good to James, who always comes and helps us out with sound. Thank you. Thank you, thank you. And to AJ Johnson, who has been busy here. If anybody's wondering what he's doing, he is live streaming it on Building Bridges Facebook page. So if you want people are interested, if you want to go back and see something again, if you want to bring other people's attention to it, please, it'll be on Building Bridges Facebook page. You can find it pretty easily, I think, with a search. Someday we'll get a YouTube channel. Get big time. And I'd like to appreciate Steve Paulson for doing the timekeeping. It was quite a manic role to do that photo. And Sonja Crawford and I would both just like to really thank you all a lot for coming out. Thank you. If there's another forum, let us know, and we'll put out some publicity about that as well. So, vote. I'm going to say vote frequently and often, but that probably would not be the right message.